Go. Good to go?
Yep, good to go.
Testing. All right. So, something I haven't done, and I should have, as it turns out, and I hope it's here. Is it? Oh, no, I was going to actually do template stuff too. So there's a couple of, let me copy and finish it, instances in real estate practice in the area where CAR doesn't have a form for it. Strange but true. There's a law, I think it's 2301 or 1102 in the Civil Code that allows municipalities to create disclosures. And they're created under the same, they have the same requirements and exemptions generally and all that stuff as a transfer disclosure statement does. So we have a few in the area that I know of that were created under 1102 as disclosures. And I've run into trouble with these before, so we'll just do them today. The other thing I was gonna show you while I was at it was I have a template that has those disclosures in it. So I have a transaction here, and I don't know why I've got so much. Oh, there, okay, good. There's the rest of it. All right, so I have a transaction open. In fact, let's do it. I did. We'll do a little tiny bit of template training right now. Where is it? There's you guys. Today must be the 4th. Computer smart. So I created a transaction to have today's training forms in it. And then I thought, oh, there's a few more forms I want to add. So I made a template of those forms, wanted to just refresh your memory on how to apply a template. So I'm in my transaction. You saw me just open it right now. I'm going to click apply template. It's going to ask me what template. I don't remember which one it was. Local option disclosures, apply. Bang, there they are. That easy, in case anybody forgot. I'm sure you all did your homework. I just never heard that it got corrected or collected. Everybody was supposed to create 2 templates, right? Did you?
No.
Did you create any templates after my template training?
Speed of the leader is the speed of the pack.
Templates are great, guys.
Hey, so, right? Yeah. Do as I say. Period. Templates are great. I can't tell you how much time templates can save. So an example of a local option disclosure, an example of an example. There it is. So click the button to learn. I've always hated the way PDFs open up in here. Anyway, so we have a right to farm disclosure. There's a little bit of confusion about the San Luis Obispo County right to farm disclosure. Probably better with that, right? Not much, but there you go. So the San Luis Obispo County right to farm disclosure, I actually got to write about one word of it. Mona Tucker was like she used to do all the time. She'd be on all those committees where the county said we need realtors to help us do a thing we want to do. So we have a right to farm ordinance in San Luis Obispo County that basically says if you move next door to a pig farm and you don't like pigs, you should just buy somewhere else and shut up. Pretty much it in a nutshell. Whatever they're doing, if it was legal, which is a whole nother issue, right? Whatever they were doing when you moved in next door, they can just keep on doing, and you better just enjoy it because you can't say, well, these guys next door, they're planting broccoli and I'm allergic to broccoli. Well, if they were doing it before, then in San Luis Obispo County, you just deal with it. I'm not aware of one in Santa Barbara County. I haven't done enough business outside of the city limits to know, but I'm not too sure that's even right to farm county. Maybe it's a foregone conclusion.
I've never seen this one. I've never seen this one.
That's one reason I brought it up. Yeah, because I was in a transaction. I still remember I was at forms training. That's a great place to get the call. It's like, hey, Howard, I have a question. The attorney that's teaching the class, now you got to go to guy right there. But I had somebody tell me in this transaction, hey, we don't do like your local forums. Like if you're Keller Williams and you have like you guys have a local area disclosure thing, right? Some offices might say, we don't do that. We're not going to do that. We tell our clients not to, like everybody, like a lot of people do. So I had somebody tell me, like, we don't do your, Gary Grasha junk, whatever that stuff is. Like, wait, back up. Like, That's a San Luis Obispo County codified right to farm disclosure, legally required in every sale outside of the city limits of every town in San Luis Obispo County.
Outside city
If you're in
limits.
Oceana or Nipomo and you're next to the bonds, you still got to use this disclosure because you're outside of the city limits.
So has escrow been you putting this in? Or
No.
is it-
No, it's on us. Yeah, it's on us.
Are we
Yeah,
supposed
this
to be getting our
is
clients
just
to
like
sign
a just like a TDS.
We've never done
Yeah.
this.
Well, that's what I thought I'd bring it up.
I wish Angie was here because we have a form. It's not a car form.
That's not a car form.
It's not a car
That's
form.
decodified form. That's the only form you can use. Every other form you use, it is not that form. You did not comply with the law. Yeah.
We do? Okay.
If you go to the Pismo Coast Association website, there's a link for that form.
Okay.
There's a link for why you.
That should be on the back end on Skyslope. I don't know if it is. So
Yeah, easy to find. Yeah. Of course, I haven't been to the Pismo site.
it's called the local options.
It's a local option real estate transfer disclosure statement. They titled it that. They should have just called it right to farm, I think, because
That's
it's
what I was calling it.
kind of dopey. But it's a local option real estate transfer disclosure statement is what the law that made the transfer disclosure statement says. You can create a local option real estate transfer disclosure statement. Now, I use it every time I sell outside of the city limits, even if it's, I don't care what it is, land, warehouse, I don't care what it is. I'll just put that in there. The requirement, which you can go to the San Luis Obispo County, it might be on the Pismo site. I just can't remember if the ordinance is on the site or not, but it's really easy to find. It's the only thing that's easy to find on the San Luis Obispo County government site, which is now the biggest, hardest to navigate piece of junk I've been on lately. The ordinance says it's basically a residential 1 to 4 disclosure, just like a TDS. But the 1102B, I think it is, gives municipalities the right to create this. So if City of Arroyo Grande had a thing they really needed everybody to know whenever they bought a house in Arroyo Grande, they could make a form and make it legally have to be in the transaction. So that's what San Luis
So
County
if another
did.
brokerage doesn't use this, and ultimately this is law for city municipality, if they don't use it, then ultimately they didn't disclose something to us about the neighbor.
Yeah, I always throw it in because it's like, it's pretty common to run into people that don't know it and that think it's been covered. Because that transaction I was in where they go, we don't use your personal forms. I said, okay, so San Luis Obispo County has a right to farm ordinance in the county. Like, how do you disclose that? Because you're legally required to disclose. So I got this email explanation, which should have started with "you dunce," the way it was written. In the natural hazard disclosure statement, it's covered. And I said, okay, I know all about that because I've been teaching this for
So how
years.
would that not differ from the NH?
There's a state law, not this law. It's a different law. This is legally required in San Luis Obispo County. Now, the state law disclosure is if you're within a mile of an agricultural thing, just like munitions dumps and all that stuff, if you're within a mile, you have to disclose it. It doesn't say anything about right to farm stuff. So I sent them a copy of the ordinance and all that other stuff. I go, hey, don't shoot the messenger. You guys are just blowing it all the time, making me backfill your deal for you, because I will. My buyer will get this form. Your people will either sign it or they won't. I don't care. I'm out. I signed it. And it's just like a TDS. I guess we go down to the bottom, transfer disclosure, room for everybody. Like the TDS, seller signs twice, all the agents, all the brokerages sign, buyer signs, everybody signs. The signature part is set up a lot like a TDS. So the NHD California disclosure, if you have to tell people if you're anywhere close to farming, is a different law. It's a different, because they'll put the civil code in there. They'll quote and they'll say civil code section like 1303B or something. This is an 1102AB, I think it is a disclosure. I have no idea what that state law is. This is a different deal. So the other, so Patterson Realty, like they changed their deal. They put it in all their deals. Now they had no idea. I've heard that about the NHD a lot. Like, no, it's covered. Like, no.
It's in all our deals now.
No, it has.
It has? Okay, well, I've just never seen it, so let's.
It's been in your deal, so.
Yeah.
Outside the county. Cool, okay.
So this is a right to farm anything.
This is a,
Really?
well, I'd say no, because it's gotta be legal. Marijuana is illegal in America. It's somehow legal in California. It's illegal in America. It's illegal right under federal laws like It's like, oh no, we didn't. California goes, I don't care. Colorado goes, I don't care. You're just like, whatever. We'll secede so we can grow marijuana.
So again,
The form is from like 92, I think, or something. Nobody was talking about commercial marijuana when they made the form, but you can't break the law. And I just got another call on that 7B22.
Yeah.
So you can't rob banks either, right? So you can't farm illegally and then get some protection from the government. Like, oh, I'm sorry, your heroin poppy field is no problem. Like, I think not. I don't think that's going to fly. Now, that's my interpretation of that. But I think if you had a buyer that moved into next to a marijuana patch and they had issue with it, I don't think the county is going to back the right to farm on the marijuana patch. They might just go, we'll get back to you on that. We're going to send that up the chain and you'll hopefully be dead by the time we hear back. So, I don't know. Yeah. So I would say, I mean, really, it's not up to us to interpret it. It's like, just put in the deal. Buyer's got a problem, buyer's got a problem. Agents don't have a problem just because the buyer's got a problem. You can run a little interference for them, help them out, but the principals are their part of the deal and we're the brokerage part of the deal, So we didn't have to interpret this stuff. We just got to put it in, especially if it's not our form. That's a county form, like a CAR form, a counter offer. You're supposed to be able to handle that form and be able to explain it to people and stuff. This is another form that you're legally required to put in. Like, you didn't write it. Okay, I did. Come to think of it, I was in on that. I wonder what that did for me, but I wouldn't worry about the interpretation. Just make sure it's in the deal in outside of the city limits in San Luis Obispo County. So Monterey County, Kern County, Santa Barbara County. If they have one, it's not that one because that's the San Luis Obispo County right to farm. Okay.
On the disclosure on marijuana, if you come across a client, bring it to the broker before we go into contractual contract on anything, because ultimately, it's too gray to not know, and there's not enough case law, and we don't want to be the guinea pig that the feds come after to make an example of the brokerage. The state won't be the one that does that; it's going to be the feds. So just bring it to your broker, and then we'll evaluate what's going on and decide how we can move forward on it.
So what form was that? Because I came to the end here.
Right to farm disclosure, local options TDS for San Luis Obispo County.
Okay.
Must be used on anything outside the city. And it will be in the back of Sky Slope under working documents.
Okay.
And apparently we have been using it.
Good for you.
But
Looking for another one that apparently I didn't put in there. I wonder where in the heck I put that. Oh, I did. Put it in the wrong place. Right. There's another one we're going to run into every once in a while, right? Mm-hmm. And this one maybe it's a little bit more subject to interpretation, but they titled it the same way. So you got another 1102B, legally required, codified form to put in your transactions, and the county of San Luis did this one too. So they titled it the same way: local option real estate transfer disclosure statement. So if you have a deal with a TDS in it, you have this in it if you're in the affected neighborhood. Just like right to farm, that's anywhere in the county where you're outside of the city limits. This Nipomo Mesa area, what do they call it? It's your name for water conservation area disclosure. There's a map. And basically the kind of like the northwest edge of that map, that's the bluff edge. So this thing basically goes to, it's called the Nipomo Mesa Water Conservation Area Disclosure, which covers like Cypress Ridge, everything to the edge of the mesa, all the way down to Las Barras Road to the riverbank.
is that all Nipomo? It wouldn't have any AG in there.
Yeah, it's all, so rural AG is, this whole end of that map is all, like Cypress Ridge is in there.
Okay.
Yeah. Yep. So you can't just go by like zip code or something. You gotta follow this map. In fact, that's probably the Pomo proper right there outlined. I should look here. I can probably see it better. No, I can't. So it goes all the way from basically it's the mesa. Anywhere where it's like you're higher than like the flatland in Arroyo Grande, it's probably in this thing. Like all those guys on Bluff Point up there, Northview, all that stuff is all in the Nipomo Mesa water conservation area stuff. So what I had been doing in the last place I work was just anytime you're in a deal where you're in that map, like Rockin' Horse Ranch, and, you know, anywhere, this end by Cypress Ridge up there, Trilogy, all that stuff is in this disclosure area. So there may or may not be further action required by this form, you know, so you get it in your deal and the form explains what to do.
Sign it.
And everybody signs it.
So Trilogy has their own municipal water company. How will this apply to that?
They're on the map. And you know, people say that. It's like, well, you know, it's a newer house. There's a lot of exemptions and all kinds of junk. So this thing actually has some disclosure about, hey, sometimes we run out of water and stuff. It's a more general disclosure than, hey, you need low flow toilets like City of San Luis or something. The amount of water being used by residential, commercial, and other uses located must be reduced. Reduction in water use shall be achieved through retrofitting. So it mentions retrofit, but it talks about the level of severity of overdraft and the Nipomo Mesa water basin and all kinds of junk. There's a lot of stuff in this disclosure. So best advice I ever got when I started was, when in doubt, disclose, 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 disclose. So what's it gonna hurt? But when they titled it Local Option Real Estate Transfer Disclosure Statement, tied it to section 1102, every deal in that map, residential 1 to 4, this goes with it. I just put it in every deal I do that's on that map. If I sell somebody vacant land and they get a surprise about when they went to go try to drill a well, let's say it didn't rain last year, we wound up in an adjudicated water basin or something, this form would have helped with that. They're not going to come back to me and go, hey, nobody said anything that, you know, you guys might have water trouble. Nah, just because you didn't read it. I totally did.
So if it was a private water company, wouldn't they still be governed by certain county regulations?
Well, it's the buildings, right? So they're talking about how we might run out of water up there and we might not. And so did NCSD have trouble with water? I mean, the Mobile Community Services District, they're buying water from Orchid, right? And they got the state water pipeline. They're trying to meet their demands and all that kind of junk. So they're affected by it if it doesn't rain. Everybody's affected if it doesn't rain. So this disclosure kind of says, hey, it might not rain and we might have more trouble. And then it talks about ordinance requirements, and it goes, so to take care of all these problems we're having that we just disclosed to you, there's an ordinance in place that says toilets in all structures on the parcel shall be changed to 1.28 or less gallons per flush. So is that a surprise to anybody? 1.28 is what you're supposed to have. First time I ever had to do this was like because this is an 2008 law. In 2010, I sold a condo in Black Lake, and the guy argued with me for a week on retrofitting the toilet. So, you know, again, I'm like, don't shoot the messenger. Call the county. Tell them what they want you to do. They had to go buy 3 toilets. I said, we're not buying them. You're buying them. Just because you don't know your stuff. I don't even want to negotiate now. Make it happen, dude. So it talks about what the ordinance requires, and then it talks about the exemptions for ordinance requirements. And there are people that say, well, I'm exempt, so I don't have to do your disclosure or anything. And I'm not going to go to court and prove them wrong, but I think, A, what's a disclosure hurt? B, it's required by the county in residential 1 to 4 in that map area, so I'm probably going to put it in. I don't care if you're friggin' exempt or not. Every single house in Trilogy is exempt, every single one, because they were built after 96. I mean, they never stacked lumber there until like 04, I don't think. So all the houses are already compliant, no problem.
Now, where would it say
Cypress
that
Ridge
they're
is
exempt?
all, pardon?
Where would it say they're exempt?
Where it says exemptions for ordinance requirements, existing 1.6 GPF or lower toilets and existing 2.5 GPM or lower shower heads are exempt. So what we were doing when this first happened was there's lots of guys in Nipomo. The house got built in 1979, right? They got 3.2 gallon flush toilets. Before the home inspector gets there, the guy who's actually empowered by the county to tell you whether you're compliant or not, because we needed an inspector, and they go, home inspectors can do it. We're good with that, which was because there was a committee of realtors working on this, and they started to push issues like, we get it, but don't make it impossible to close the freaking escrow. You know, just give me some help here. And this was, I forgot what they call them, commode commandos or something. Mona Tucker again, her last contribution basically. But so what we were doing was if you had a 3.2 gallon flush toilet, And everybody hated the 1.28s because I don't care how many golf balls they can flush, and they'll flush anything else. So we'd go in before the home inspector got there and get some, $100 Home Depot 1.6s, toss them in there. I go, now I have an existing 1.6. Before the inspector got there, and kind of goes, good, we got what we want. We got rid of the 3 2s and the 5-gallon flushes. That's what we wanted. So the exemptions are right there, and I think there's, where is it? I don't know if it says in here, blah, 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 water conservation certificate. In the ordinance, it talks more about, and I can't remember the year, it's either 92 or 96, but the ordinance is, that might be on the website too, I'm almost sure it is. So the ordinance is floating around somewhere too. So anything, so if you use 96, like no problem, because I can't remember whether it's 92 or 96. I know it's not any later than 96. That the house is okay. Anything with 1.6 gallon flush toilets, we've always rather assumed that they have the 2.5 gallon a minute shower heads. Because if you have to replace a shower head now, good luck getting a shower head that'll let any water out. So, everybody's been so compliant for so long. California's always dry, so we've had a lot of, you've only been able to buy, water efficient stuff for a long time. So, any questions on that so far? So you guys will have to talk about whether you want to put that
So
in there.
this is our 7B2, B1, B2 on the contract.
Yeah, you know what? To me, that 7B22 or whatever that is, this is what they're talking about. They're talking about mandatory government inspections or retrofits. And then what I guess is bothering people, it says in that clause,
After close.
if the obligation survives the close of escrow. Well, if you have a mandatory government retrofit, like what is mandatory? It means freaking do it. The law says it's like drive in the right lane. It's the law. Don't drive in the left lane. Don't drive in oncoming traffic. Those are bad things. It's a mandatory deal. It's like, you have to do it. Will it survive the close of escrow? It will if you don't do it. Like, just do it. And because we don't have a retrofit or an inspection or anything that I know of that survives the close of escrow unless you didn't do it. So if you're exempt or compliant or whatever with the Nipomo Mesa Water Area Conservation rules, you're done. Like, all you got to do, you got to do it by the close. And when it closes, there's a certificate on file. There didn't used to be. They had a hell of a time with it for the first 5 years because the county, after they went to all the work about wanting the ordinance, they didn't want to work on it. They wanted home inspectors to inspect it. They didn't want to do certificates. They go, God, that's such a pain. Just tell me it's fine. Now they finally got some college kid in charge of it. I forgot what her name is. She chews gum when she's talking to me. It's probably forever 22. and they're tracking it. So what you can do finally now is there's probably a place, you'll have to go look, to go on the county's website and go look and put in an address and go, is there a cert? Okay, cool. Like, you don't have to do anything with that house because it got certified. Did something change in the meantime? The home inspector go in there and say, hey, they put all the 3-gallon flush toilets back in. Okay, now you have a disclosure problem. You found out, stuff that's not right. So worst case you can handle it. You might have to handle something like that.
So would you say the 7B1, the very first clause that says any mandatory retrofits, we're checking that the seller does. Right below that, it kind of seems redundant that they're saying 7.1 and 7.2, because 7.2 just says that it needs to be done after the close of escrow as well. Well, you're going to get to it.
Yeah, let's have a look at it.
We ran into this just this week, and we settled on, as long as this one box was checked, we should be able to win the argument that they're going to fix all mandatory retrofits. So item number B2.1 and B2.2 seem redundant, and I don't know the interpretation of one or the other except that clause of after the close of escrow. The seller was giving us grief that we don't want to be liable for anything after the close. And I said, that's fine, but you are saying that you're going to do it prior to close of escrow. So we agreed on just checking B2.1 and calling it good.
I think that could be. What you want to make sure you have is B2.3 in there. But I'm thinking that because it's a 3, it's like not part of B2.2 2 or whatever that is.
Yeah,
It's
like
its own
automatically comes
standalone.
in.
Buyer shall be provided within the time specified in paragraph 14A, which is how long by default?
7 days,
7 days, right? So hurry up, Mr. Seller, get me that toilet cert.
which they never
And
will.
that's a done deal. Yeah, somebody's gonna have to run it down. It's gonna be the agent every time, because the seller's going, what the hell are you talking? And if you don't have a mandatory government retrofit, like your house was built after 96, for instance, or it's already compliant, all that kind of stuff, it's kind of no harm, no foul.
The listing agent, I've already ordered the cert and they've taken the listing.
I know, it's.
Wouldn't that be
negotiable.
awesome? Oh, look at
I'm
that
just
Tennessee
saying, come on,
fairyland you
basis.
live in. That's
It's a
great.
negotiated item. It needs to get done, but who's gonna pay for it is what you're negotiating.
So if the cert's on file, it's free, right? I mean, as far as they go, sure, yeah, that'd be great, yeah. Added value added or whatever they call it. Yeah, I took care of some of your stuff for you. You know, I see that you're already compliant with your retrofit stuff. Oh, didn't even know there was one. We just bought the house. Blah blah. Look at you, you're a genius. See,
That would be an amazing listing agent.
how about that? Yes, I've met that
I'm
one.
not
I don't
So
Cool.
we would win that argument if they came back and said, no, we don't wanna do this government retrofit. Item 1 would say, you're agreeing to do all retrofits. I mean, that's why we settled.
Yeah, it
was-
says inspections and reports, right? It's pretty much only it doesn't say retrofits. Then.
Are you saying on B1?
I'm saying, if only.
B21 says any minimum mandatory government inspection and report. B22 says any other minimum mandatory government retrofit standards required as condition of
B1
closing.
is smoke
So I don't
alarm.
know why they separate it. Well, smoke detectors and everything are B1.
One is they have to do the inspection and reports. 2 is they actually have to do the work.
Okay,
2 is a retrofit. 1 is not. So that's almost all we have here is retrofits. We don't really have a government mandated inspection required as a point of sale.
2 is a
Like,
word, 1 is a report.
Like everybody has to have 4-foot square windows or something. They come. Well, I guess that'd be on back to retrofit. Right? Most of this stuff's retrofit.
What, Ryan?
Yeah, if they want to get rid of some, get rid of
Contracts?
B2.
You want him mute? Okay, no, that's good, because I.
Yeah, good thing you brought that up. I hate when I have to actually read it.
There you go.
And I've only been practicing law since 10.
Can't you just go look at the toilet and see if the seller's compliant?
Yes.
Would you go look at the toilet and see if the seller's compliant?
Yeah,
You're not
Where do you work
certified
now?
right
well, it says it right on the toilet, gallons per hour.
Not to you, it doesn't. You're a real estate agent. That's beyond the purview of your expertise. That's way outside of the scope of your inspection.
You can
If you look
say
at that
it is.
toilet and it's broken, that's what you're looking for. If you look at that toilet, you're gonna identify it and take them off the hook for the retrofit. We got other guys to hang out for that. That's why the county said, we told them we ain't doing it. Now, do I look? Every time.
Yeah.
When I'm doing my Avid as the buyer's agent, like if somebody hasn't told me anything, I'll say stuff like GFI is like not apparent. Like I'm not too sure, but I'm not seeing it. I'm just saying.
Well, when you're getting signed this document, I would think you need more.
You're not
So,
authorized to sign.
Huh?
You're not authorized to sign.
I'm talking about when you're getting the buyer or the seller to sign this document.
So the seller's not authorized to sign it either, is it? I thought
Where are
the
we
home
at?
I
inspector
mean, we're
was.
talking about requirements in retrofit on toilets and carbon monoxide alarms. I mean, if there's a non-compliant toilet, and that we know that's gonna be an issue coming up in the future, why don't we go and address that?
Why don't you go talk to the seller about it? Yeah, sure.
What
Hey, what do you know
you
about
could
this
do-
toilet? They don't all say 1.6 on them. The 1.28s don't say anything because they hate it. They're the ones with the 2 buttons on top. One of them's like one drop and the other one's 2 drops.
Everybody go with the toilet?
That's all.
Yeah, that's probably
That's
a
addressed in
combo
your
1.28.
pre-listing inspection.
Pardon?
That's addressed in your pre-listing inspection with your home inspector before you take the listing.
Sure, if you all.
Could be.
Yeah. They don't do pre-listing inspections
Oh, yeah,
anymore.
they do.
Yeah,
Not here.
that depends how busy they are.
Cornerstone doesn't. They don't do them anymore. And they were.
When they
the
need
ones-
money, they'll
they
do
were
it.
the
When they
only
don't
ones
need
that
money, they'll
weren't
push
doing
it
it.
off.
So ultimately, can the seller sign this off? Can the seller be the one that says we are compliant?
Steve.
Or does
Oh,
it
yeah,
have to be
it's a seller disclosure
third
problem,
party?
right?
Seller
As far as that goes. So, can they, well, there's, I'm trying to think. Because
I
there's
thought the
4
license
places
plumber-
where there's 4 areas where that happens that I know of, and there's probably a 5th I don't know anything about. In fact, further to all that, was it July of this year or is it January of next year? The entire state of California goes low flow, period. This year, right? Because we got the water conserving appliance, blah, blah, blah. We have another form yet that I probably forgot to throw in with the TDS and all that other junk. And it's, and on the SPQ's been changed to reflect it, right? Yeah, we're probably gonna go over that again. That the seller discloses, or reports, I guess you'd say, on the SPQ, whether or not they're aware that they have a non-compliant device. And we beat that language to death, like yes means no, no means yes. I forgot what they finally wound up there. But so on the SPQ, the seller has a chance there to say like, nah, we're good, or no, we're not. But it's, they use the term, when I started, they used the term risk shifting. And when I started, like everything was legal. Who cares? It rained back then. We didn't care. We didn't have low flow toilets or any of that junk. They invented the TDS like the year I started. So we didn't have a whole lot of disclosure stuff. Back then, we still risk shifted. If we could put somebody else's butt in a sling for it, we did. It's like, hey, agent, what do you think about that? You know, hang on, I'll get a guy. No, nothing. I don't know nothing about burden. No babies missed out it. So that's why the first page of the app says, I don't know anything. I'm a real estate agent. If you expect me to like identify compliant features and stuff in this house, you're going to be severely disappointed. That is not my job.
So if you're a listing agent.
And you're not empowered to do it either. The home inspector is. The county said, we'll take the home inspector's word. They won't take yours.
I'm doing something new here with this whole dynamics of the pre-list inspection. I haven't heard anything of such.
No, I've never done them.
But said that they stopped doing it because by the time they went through the pre-listing, they might as well have done a whole home inspection.
Yeah, because you're in escrow next week. Yeah, the market sped up a little bit.
Well, look, the work that they were putting into doing it, might as well charge for a whole home inspection.
I think we beat this horse enough.
You ready?
Moving on.
Yeah, all right, okay.
One last question. So you're the listing agent. First 7 days, you're checking to see if this house has been certified or not.
So where do you check?
With the seller. And if the seller doesn't know, then you need to get a plumber out there or someone that's certified.
Or you can just, so San Luis County's got a lot better now about keeping records. If they know, so two things. If there are exemptions, right? So if a home inspector says you got 1.6 toilets, like, don't worry about it, right? If you're in, now we're just talking about this Nipomo Mesa thing. Time is it? Yeah, you're right. If you're pretty sure the house was built after 96, like you're in Cypress Ridge or Trilogy, that's like automatic. I mean, they never built a house in either one of those guys till like, who are those guys? Cypress Ridge was probably 2000 before they ever stacked lumber up there, probably 04 in Trilogy. So they're good. I mean, it's almost like we're putting the disclosure in because it's part of the TDS and the disclosure obligations of the seller, but we're not too shook up about the whole retrofit deal because there's so much evidence, as it were, that you're compliant. You're actually exempt from the ordinance. So you don't have to comply with an ordinance. You're exempt from it, right? So that's your protection, I guess, as an agent. Like knowing that this house was built last year, I'm going to put the disclosure in, but I'm not really worried about having a home inspector come out and tell me. If anybody missed it, it was a county building, because it's a brand new house. I think that's all I have to say about that. Did I get there? All right. So the sad part is,
buyer's agent, you're waiting for the seller to send it to you. Selling agent, you're going to get on it.
oh yeah, that's where I was going with that. Sorry. So you can go to the municipality if you're in the.
That's going to have an effect on you closing it.
That's part of your disclosure, so you need to disclose it to them within your 7-day period. If you're the
Through
listing
that
agent.
form,
Through this one.
if it's on the Mesa, but Grover Beach is different.
Part of the
Grover Beach doesn't have one that I know of.
Okay. So this house
Yeah,
has-
Arroyo Beach doesn't even have a retro. Okay, everybody's on Lopez Water. Why is Arroyo Grande the only one with a retrofit? I don't know. No idea. Well, that's kind of stupid. So I'll ask a question, and then if I get the right answer, I'll skip a form. What you be said. Is that right? Okay. You may be a huge help to our actually finishing before 1. That was the Nipomo Mesa. Yeah, Nipomo Mesa Water Conservation Area disclosure. At the same time, they created a duplicate disclosure. It looks exactly the same almost because it has a different map for where. All the same rights, rules, everything, disclosure obligations all apply. Where is it?
Just for Nipomo?
No, there's a whole nother, there's a sister ordinance, I guess you'd call it, to this, that applies somewhere else in San Luis County.
Las Osos.
Las Osos. Same thing, same display. This is Title IX, they're Title 8. Same form, that's supposed to be in your Los Osos deals. And means that's also in the county, you go to the county to see if they got a certificate on file. Now, I think, like for Ben's saying, okay, I'm the agent, I kind of want to just sort of handle this stuff, you know, like make sure I can handle it up front if possible. Look for the cert. City of Arroyo Grande's got them on file. City of San Luis, there's a website, you click on the address and it tells you compliant or not. There's a little map. You just click on the little button for the house and it tells you. The county, they now have certificates. You have to go to the website and figure out how to get them. I forgot. Can't remember. Haven't sold enough old junk in the county lately, I guess.
So Elizabeth got it. Which form are we skipping?
The one that looks just like that. The Los Osos doohickey, right? That takes care of that, I think.
That's
So,
not correct. The agent should never sign and certify this stuff. They should
You
not be the one.
can. It says right in there that it has to be a home inspector or plumber, but it can't be
That's
the
why
agent.
you would
But you can,
always lose.
but you can deliver the cert, like if you're City of Arroyo Grande and you're the listing agent, you go, hey, hey Glenda, you guys got a cert on, you know, blah, blah, whatever address. Can you fax it to me? Yeah, here, you know,
Yeah.
all right, good to go.
Down, that's what you,
That's
you
what's
walk
supposed to
down to the
happen.
city and you say, you
Just handle
sign
it.
and they sign it, and then you come back.
Or you go down to see Glenda and get some referrals.
Yes, you can.
Only don't. Glenda and I went to high school together. We're not skipping the rest of the form, just so you know what they look like. You'll be looking in your City of San Luis deals, look for this form.
That is on the back.
San Luis Obispo City retrofit verification form. That's for the City of San Luis Obispo. Now, it'd be great to have that form in the deal. We were getting by at Prudential. I was letting them get away with the little printout from the website where you click the button and it says, yeah, that's compliant. And we were just doing screenshots of clicking the button on the map and the window popping up going, you're okay. And I'm like, I'm good. We're not responsible for keeping their map right. But if you can get your hands on this cert, which would be a lot harder, like you might have to call them or something, that'd be awesome. And I think, yeah, and it explains the retrofit there. And Arroyo Grande, same way. There is a cert. Arroyo Grande doesn't have a website. That'd be awesome if they'd all do that. Like click, bang, oh, we're good. Not yet.
So this is relevant regardless of whether you're on a well or city water.
Depends. Yes. I mean, make a long story short, yes. So if you're in the city, right, you're on city water, pretty much. It's really hard to maintain a well in the city. That's where I learned how to abandon wells, was wells in the city. On the Mesa, unless you're in a subdivision like Cypress Ridge or somewhere, or a bunch of 1 acre lots in Nipomo, you're probably on a well. So yeah. Regardless, yeah. Yep. We have low flow toilets on the ranch, yeah. Because the real estate agent lives in the house. That's the only reason. Because, you know, and because the 3.2 I had in there, which was a dynamite toilet, you know, 5 gallon bucket of water. You know, I broke it. I was fixing the damn handle on it one day and put a wrench behind. Don't put a wrench behind something on porcelain. Broke the tank, these smithereens. Drain the tank before you start working. Just saying. We did get a new floor. Guess who doesn't need plumbing? We're working on that. Okay, so let's start burning through some of the rest of these forms. What are the ones that, so the RCSD, we've kind of beat it up pretty good. Right? How do you feel about that? Pretty confident? Well, you know, call if you have trouble. A form I had to use just lately, and Rabobank's loan rep comes back with, what? Was the tenant in possession form. So there's stuff that happens in your deal. Maybe the seller's going to stay over for a while. Maybe the tenant's going to, maybe you're taking it, maybe you're buying a duplex and you're not moving in, you're keeping the tenants. You know, there's all kinds of times where we're going to run into these forms. So I'll start in the middle and go both ways. Anybody? Start in the middle and go both ways. But there it is. Must be like a sweet spot to click on. Nice short form, right? Buyer, seller, no agents. Tenant in possession form. So I just wrote an offer to a seller that's got a tenant in the house. And they go, we like everything about the offer except that we got to kind of wait to get the tenant out. You know, we don't want to do that. In fact, we don't even want to talk to the tenant. In fact, he's now your tenant. How about that? So my buyer has to decide whether he wants to do that or not. So we countered the buyer. Sounds like a double-ended business. So we countered the buyer with this counter offer that said, hey, the tenant's gonna remain in possession, see attached CAR form TIP, tenant in possession addendum. This is an addendum to whatever it was. So at that point it was an addendum to the counter offer. Buyer, paragraph 1, buyer shall take property subject to the rights of existing tenants. Seller shall transfer to buyer through escrow and use tenant deposits, blah, blah, blah. Whatever, you're gonna be the landlord, I'm just gonna push everything over to you, deposits and all that junk. This will work as an escrow instruction to help escrow with that bookkeeping and all that stuff. Great little form, nice and short. Seller's got some obligations. Now, why they didn't just tie this to 14A, I don't know. They should have, instead of putting time periods in here, because it creates another time period. Seller shall deliver buyer copies of all estoppel certificates sent to and received back, leases, rental agreements, current income, expense statements, blah, blah, blah. And if you're going to change the lease before you close the escrow, you have to tell the buyer, and the buyer's going to decide whether they like that change or not. Just raise the rent, they'll be okay. So what's an estoppel certificate? Anybody?
Wait a minute, if you change the lease after the close of escrow?
No, before. Seller shall give buyer written notice of any change to existing leases or tenancies or new agreements of lease or rent, proposed changes, at least 7 days prior to any proposed changes. And while the seller is still the landlord, we haven't closed the escrow yet.
Okay.
Estoppel certificate is information on the tenant and the lease payments, how much you pay monthly. You usually get it from the property management company.
Or if you don't have one, we have them. Like you see, Eric's got that form. We have estoppel certs. So basically you get the tenant and the seller, the landlord slash seller, signing on one form going, yes, that's how much deposit I took. Yes, that's the rent you pay. Because the tenants are, sometimes they think they gave you $5,000, they gave you $500, and they really want to ride that horse after you take over. So the estoppel certificates, the tenant says, I have a $5,000 deposit and I pay $300 a month. And then you take that to the landlord and go, that ain't exactly right. Take this back to him and tell him like, oh, no, you didn't. So the tenants fill them out and then the landlord signs it. That's how they work. And if you got a property manager in place, awesome.
So does this document address where the deposit goes? Because the estoppel just clarifies that there's a deposit.
Yeah, paragraph 1, yep. Seller shall transfer to buyer through escrow all unused tenant deposits, if any, all prepaid but unearned rents, if any, and escrow prorate rent.
Now, why does escrow require a new document on the clarification of deposit? Or so First American is requiring another document on top of this to say that the deposit is being transferred from seller to buyer. And it's right there in black and white.
Well, partly, I'd almost bet because, okay, that's a good question. This will work, or I should say this has worked, but escrow is only concerned with certain paragraphs in the RPA and they're numbered. So attaching this to a counter offer, escrow might think, okay, that's not in our paragraphs, we want our form, and they'll do redundant forms. They always will, never stop. So what's it gonna hurt?
Okay.
But that's a fair question for Stacy Friday or someone's, why do you guys make his word so hard? Stop it. Knock it off. And it's okay that they have their own forms. I mean, that's our request for repairs get handled, right? Those don't go anywhere because we're negotiating some stuff that until we're done, we really don't want anybody to know about just how bad that house was necessarily, or how bad we think it was, or how bad the buyer thinks it was. Until we're ready to do the transfer of money or whatever's going on, and then escrow can create or you can make an addendum, or they can create an addendum to address it. So I'm not surprised that they want an escrow instruction, even though this should qualify. But I mean, they have more attorneys than CAR probably.
Would you say an escrow instruction supersedes an RPA contract?
Escrow instructions are written, and it's a good thing to check. They used to ask us, I keep telling these back in the day stories. So the answer is no. It says right in them, does not amend or supersede, which I always thought, how the hell can you guys amend a contract that you can't amend? And they did it all the time. I can't stop old brokers from having escrow amend the contract. They can't do it. They just wrote a document that says we will not amend or supersede the contract. So even if that new escrow instruction says I hereby amend your contract to allow me to amend, like, no, you didn't. No, it didn't happen. That's not a contract. Can they, so amend or supersede, they can't do it. They can't supersede the art. They can't change your deal. I've gone to them for language before. Nancy's not here. For like, hey, we got this weird thing going on. We're gonna need some help with the language. They've crafted every clause that's ever been used in a real estate transaction. They probably got to drop down 9,000 clauses. It's like, hey, we got a thing where this is kind of happening. I want to craft it, but you know, I'm not an attorney and all other junk. So you guys got language for that? Like, shoot it to me. I'll put it on an addendum and I'll have everybody sign it. Don't send me an escrow instruction without on it. But you can do that if it's okay with Bob and Dave. But I hate escrow messing with my contracts. It's just a pet peeve of mine that I don't want instructions rewriting my deal. I want my deal in my zip form stuff, my CAR forms, and your instructions reflect my CAR forms. That's like a pet peeve of mine. I don't think that's even the law or anything. But we were taught does not amend or supersede, and I won't let them. And they love it. Boy, I had to take them to the movies one night so I could keep being an idiot and a pain in the butt. That was fun too.
It's a good movie.
Everybody there, yeah, you want to do something cheap for escrow that they get a kick out of, take them to the
Take 'em out.
movies. It's cheaper than taking them to eat. It's like, oh, $8. Hey, everybody's over 60, right? Some of them are like, no. Oh, no, you didn't. Like, I just don't look. A bunch of older ladies come in and just want to buy them online. Here, take your ticket and step away. I'm 27 years old. My grandma couldn't make it. So those are good. These are great questions. That's what I love about live training. No offense, Trina. Who now is muted, so she can't go. Shut up. Any questions on that? TIP form. Hearing none, moving on. So they just changed this form, and I think they did a really good job with it. Am I full screen? Yeah. Questions? Somebody started talking.
Just the TIP form. So that's the clause that talks about possession. If your seller's not coming in to take possession, you would check the box, tenant stays in possession, then that would pull it in.
Right. Yeah.
So
I'm
all
pretty sure there's a check box. Yeah. It's you can pull this in with the ARP. Now I wrote the offer for that guy. He wanted the tenant out, so I left it. I didn't touch it, and that means that tenant occupied properties, tenant will be out 5 days before it closes. Escrow is pre-printed in the RPA. So the seller says, you know what? He's 150 G's short on the price. Tell him to take that tenant. That's fair. You know, $150,000 worth of grief just to evict the tenant. All right, okay, yes. So then I attached the TIP to the counteroffer, but it is mentioned in paragraph 9, I think is the occupancy paragraph now. 9's the old 5, 4's the new 7.
So if you have a tenant in possession property,
yep,
that's something you need to talk with the lender about to make sure that.
Yeah, that's the next place we went. I wrote the counteroffer. The guy says, I think I can deal with that, because I thought he'd just go back to them, get the tenant out, come on. And he said, I can probably deal with that. I said, okay, stop right there. Now we got to go to the lender and say, does your loan program allow my guy, and I have a question for everybody here because I don't know the answer to it. Does your loan program allow my guy to buy a property and leave a tenant in it? Because they don't all. Some do, some don't. Most conventional loans, no problem. FHA and VA, that guy's, they got to know that guy's getting out of there pretty soon. And FHA won't, neither one of them will make a loan on an investment property. So you can't leave the tenant in there, or now that loan program was like somebody lied to somebody. You know? Yeah. So right, that's the next thing you want to do is talk to them. Hey, you okay with the tenant remaining in? And then that's your ammo for going back to the seller going, you know, I appreciate that. I mean, that's what I do, but my lender won't let me. So I'm sorry, you're going to have to get them out. Let's negotiate on how we're gonna have that guy get out and make you feel comfortable that I'm going to close.
Because if you don't have that conversation with the lender, it will come out because it's going to show
No,
up.
it's in the contract.
Yeah.
Somebody's going to catch up with
After
you.
you lift your contingencies.
And escrow's going to move the deposit and all that stuff, you know, and the closing statement's going to show like
Deposit.
$3,500 credit buyer, blah, blah, blah. And the lender's like getting everything matched up to go to the closing disclosure, like, wait, what?
And there are tons of lenders out there
What
that'll
did you
just tell you,
do?
it's okay. You don't need
Melissa,
to tell
what
the
did you
underwriter, it's fine, look, I can get this through. It will always come up on the HUD because they're trying to get you to go, well, let's just do the deposit outside of escrow. We can't put it on the HUD because it'll jeopardize whether or not this loan will work. I mean, I'm literally having this conversation this week. So you need to be upfront to make sure you don't get into a contract and then find out that the lender didn't structure the deal around your contract. And the underwriter has no idea the tenant is staying in, even if it's 15 days after the close.
And they're making their owner occupied loan and all that
They're doing
stuff. Like, you're not moving in. Like, so I was gonna come by and see you. Where the hell did you live? What's up, Ben? Did you not move in? Isn't that your boat?
Sounds like a slippery lender to me.
Yeah.
Yeah, don't it? Yeah. Yeah, outside of escrow is like, we don't rob banks either. I mean, that's an awfully blanket way to look at outside of escrow, but it's so hard to do something outside of escrow that's actually legit, that it's like, why are you hiding that? Why?
But they get you all the way down to the close and you're 5 days from closing, and then all of a sudden, there's a problem, we need to do this if we want to close it. And now everybody's going, what do I do?
You gotta get the tenant out of there to be able to close.
You
That's
can't.
right.
You can't, so ultimately,
Yeah, ever see
It
Pacific
creates
Heights?
a
The tenant
huge-
has that.
It falls on escrow.
it falls out.
Okay.
It falls out, or you're just extending because now you gotta go through the proper channels, which you should have done at the beginning.
The loan's already locked.
Yeah.
So they're,
It's a big deal.
It's a big
So this,
gotta
if
be-
there's a tenant in place, all this stuff needs to be very upfront. And when you make sure it's upfront, you need to make sure your lender is on board with making it upfront with the underwriter. Because the lender might tell you that you wanna see it on your, you wanna get these documents over to escrow, because all that information goes to the lender and they can't get around that.
Is it legal to do anything outside of escrow?
I mean, that's a real, like I was just saying, that's a huge blanket statement for like everything outside of escrow is legal. Nah, not everything's illegal outside of escrow, but outside of escrow is always considered by risk management circles as what are you doing? Risky, thank you. As suspect, as why are you hiding that? You know, it's a federal offense to defraud the lender. Are we hiding something from the lender? Are you sure you want to do that? So I don't know, you gotta get some advice every time probably. Is there anything can happen outside of escrow? You can buy that lawnmower outside of escrow. In fact, you
Personal
better.
property
You know,
happens
yeah.
outside.
Yeah, so I actually meant to scare you a little bit. Just a little, like, you know, so that little bell goes off. Oh, outside of escrow, wait, I need to make a phone call. I'll be right back. I'll be right back, sneaky buyer's agent, hang on.
Because on our guest house, we couldn't claim on our loan with Glenn. Glenn couldn't use any of that money that we generated off that guest house for anyone.
Because you had an illegal rental, right? Bingo.
Ching.
Does it ever happen? Yeah, like every converted garage in America is probably an illegal rental.
Well, now the AID,
If you use, but
ADUs.
you can't count that as income goes wrong.
If you would still disclose, you just can't count it on.
So Forever 21, you know what ADU means?
Accessory dwelling.
Additional dwelling unit. And that's just.
You
passed.
Don't blank on me.
Additional dwelling.
Whatever you're using, acronyms, always want to explain them to the new people. So another acronym, SIP. So they changed this form, they did a really good job with it, and they created a license instead of a lease. We used to have so much trouble with the buyer turning into a landlord for a minute, which just changed everything. So the seller in possession addendum means the seller's not moving out. The last one we had the tenants not moving out. So now we got a seller that's not moving out. So we got a seller that says, hey, I'm getting a new house built in Trilogy, you know, and I know you guys you want to close escrow and stuff, locked your loan, you got something pushing you to close. Yeah, we can do that. We'll do that.
Trina, listen to this one.
We'll do that. Seller in possession addendum. So seller, you can hang around for a little while. You're gonna hang around for a week. Right. 3 days maybe something like that. A lot of times the seller's got no money, so they close the escrow, then they call the moving truck because now they have the money to write the check for the mover. So the seller might stay a while, might stay a day, might stay over the weekend, might stay a week, something like that, just a little short time, which is it's a rental because now all of a sudden they're a tenant, you know, it used to be a problem with that. But CAR changed this form to if they're staying, I think it's 29 days or less, it's probably on here.
Yeah, I thought it was.
Less than right there, less than, you can't see there, and less than 30 days right under the last yellow bar there. Intended for short-term occupancy, i.e. less than 30. That means not 30, right? 30 is not less than 30, 29 days or less. You'll give them a license to stay. Does anybody else know another example of a license?
Airbnb. Vacation rental.
Is that what they do? Well, I was going even,
It's just anything over 30
Dumbing it
days
down.
requires a virtual agreement.
yeah, pretty
It's
much,
just
yeah.
getting around that.
So a license is like when you go to the show, like we took the girls to the show, they had tickets to get in, that's a license. Yeah, okay, in 2 hours, get out. That didn't create a tenancy, like I didn't like Edwards didn't become my new landlord. No, I have permission to hang on for a minute. Someone has permission to hang on for a minute, 29 days or less. If it's gonna be longer than that, then it says in here, you have to create a rental agreement such as the CAR form residential lease after sale. There's a special one for this because it knows it's weird. It's not like a regular tenant. It's the guy that owned it yesterday. And it talks about who's paying the water bill and all that junk in about 5 pages and stuff. Okay. She wants
Gary, is there one, maybe you're going to get to it, for a buyer that moves in before it closes?
No. I mean, there could be. There used to be one called the IO, interim occupancy agreement. I just tell everybody don't do it. There ain't an attorney in the world that will say that's a good idea. I'm pretty sure it's in there called the interim occupancy agreement. You can check. It's just so risky. I mean, I've been doing it long enough, and I've seen houses burn down between Friday and Monday. And last thing you wanted was a tenant and they're burning the house, or a buyer and they're burning the house down early. There's all kinds of supplemental forms floating around about we're going to put our stuff in the garage, but I've never met the attorney that said that's a great idea. Most of them are going like, do you really have to do that? Can you not think of something else other than early occupancy? Now you got Pacific Heights. Everybody, that's your homework between now and Christmas. Watch Pacific Heights.
Oh, yeah.
Right? Michael Keaton.
Yeah.
It's like, the next thing you know, the guy that owns the house is in jail. His wife's like held prisoner by the tenant, like, because they have tenants' rights. Buddy, she fixed him. All right.
Have one of those pods.
Yeah, something like that. Anything like that. The other one I want to kind of touch on, and I think we have, you see it in the hot market, and weren't these alphabetical a minute ago? Stop. Oh, no, that's all I want. That's spelled background. Did I not put that in there? Oh, I know what I did. Come back.
Everything we do has a form.
Good Lord Almighty. I got a minute and a half. I'm good. Not for sure I had to. I didn't do this already, did I?
What are you looking for?
BUO.
Fire.
What's a BUO? Anybody? There it is. Good Lord, that was a lot more difficult than I thought it was going to be. Few forms always go to the bottom in case you're looking for one. Well, that other form reminds me too. Yeah, I'll do that in disclosures. Backup offer addendum. So this is where I wanted to write a backup offer on a listing in Lompoc some years back. The president of the Santa Maria Association of Realtors was a listing agent. And I said, hey, I think maybe we want to go in backup. She goes, okay. We'll be in touch. No, I'm not kidding. So how do you go in backup? What would happen? So forever 21, you're the listing agent, and I say, I want to go in backup. Here's my offer. What do you do? Well, you don't do it. You don't do it unless I forgot. But yeah, that's the best answer. Somebody writes you an offer. You have an accepted offer already, and somebody writes you an offer, right? So if they write you an offer, your seller can't accept it. You can only sell the house once at a time, you know. If the escrow falls apart, maybe people get to make more offers and all that. Things change then. So somebody writes you an offer, and you say, okay, but we have an accepted offer. Look, I told you. Do you want to be in backup? And if they go, yeah, that's what I wanted to do. So then you can counter them into backup, or you can tell them, you need another form. Can you just handle that for me and attach it? So the backup offer addendum attached to the purchase contract allows you to negotiate the entire deal out. You can go 5 counter offers if you want to. You go back and forth until you have the dream offer created. This is awesome. That's all good. And everybody needs to know, and they will through the backup offer addendum, that we have an accepted offer in backup. And you're in backup position number whatever. And there's, so the first guy in is backup position number 1. The next guy in is backup position number 2. Subject to the rights of backup buyer number 1, who's subject to the rights of the primary purchaser, who's actually in escrow now. And you go all the way to 5 on these, because we did. Betty Lou did that one time, got the house. Hell, was Amy had to call her up and go, yeah, hey, everyone's gone, and we have you guys accepted in 5. Are you still in? Like, oh, yeah. Wait, where? What? Sure, I guess. I don't know. Let me find out.
Is there a spot on the RPA that pulls this in, or this document just hooked to the California purchase agreement? Or like under terms, do you actually put other terms, backup offer?
There's in paragraph, and I wish I had these paragraphs memorized, but I think it's 5 where there's all kinds of check boxes, addendums and advisories.
There is a checkbox for backup.
Can't remember if there's a checkbox for backup right there, but there's a checkbox for other, and that's where usually I'll run that whole line out because I'm addendum happy. Because it's like, I don't want to compose this junk. I mean, that form book, there's probably a form in here.
Okay.
Excuse me, Gary, if it's, yeah, I know on MLS if it's active, taking backup offers, that's one thing. But what if it's just plain old pending? Some pendings fall out too. Can you make a backup offer on a pending sale?
Well, it's pending. You make a backup offer to anybody that'll take it.
You
Right?
call and ask them.
It's like, hey, so I mean, that's my client's property, and I understand you're getting ready to close like tomorrow. Hey, things happen, pal. I hate to be the one to break it to you, but you might not get paid Friday. I'm just saying.
It just sounds.
Yeah, just find out. You guys be interested in backup. And the beauty of backup offers for a buyer is like never hesitate, other than it's going to take you some time to put the thing together, negotiate it out, and all that stuff, because it's just like writing a regular first place purchase offer. You have to create an accepted offer. You have to go into contract subject to the rights of the primary purchaser, which the backup offer addendum addresses and takes care of. But the buyer can tomorrow go, never mind, you're out. So there's like no harm, no foul for a buyer to write a backup offer. You can write them all over. This is the one time you can write 11 offers. You can backup behind every.
That's why I don't understand listing agents who don't want to take backup
Right.
offers.
I will never understand that as long as I live.
It's like, no, we're okay. It's like,
yeah, all right, okay, that's good. I'll wait until like you're 3 days before you close escrow, the deal falls apart. Your seller was actually, the motorhome is packed. It's actually hooked to the giant bus, which is going onto a truck, which is going to New York, and this deal tanks. Oh.
No backup offers.
No backup offer.
Doesn't seem like.
Pardon me while I pick up the pieces of your jilted romance. Just exactly how much did you need to get to New York? Because that's all you're going to get. Sam. Right, that's my dream negotiating position as a buyer's rep, is jilted escrow, canceled, horrible thing. I'm going to come in and save the day for probably a little less.
But you're also.
But when you're trying to tie it up, you want to go in the backup and solidify that position. And then your listing agent is like, when they're talking to the buyer's agent, right? I'll let you talk in a minute.
No, that's all right. I'll forget about it.
Maybe you should talk now.
No,
And then
that's
I'll,
all right.
oh crap, it's all gone.
Sure, it's gone.
All of it's gone. It's gone. And we're done. So the listing agent, when the buyer's agent goes, hey, I'm just thinking about that thing about the, I don't know, fill in like whiny, whinging complaint about the house here. Like, oh, you know what? Beat it. I've accepted backup for another $5,000. So you sure you want to rethink that? I'm just saying. The other agent on the phone go, you guys still want this backup thing, right? Because I'm about to play that card. You about to play that card.
make sure first.
Hey guys, you guys doing okay? Like, you got that loan all done and everything? We're good, okay. I don't know how things are going here, but just figured I'd check in. Thanks. Here we go. Get out. Oh wait, I gotta notice you. I wish this didn't take 2 whole days. I'm just saying. Be nice. So, any questions on the backup offer?
time periods, can you get the contingency period to start even when the first escrow is going?
You can't. Paragraph, so 1, 2, and 3. Paragraph 1, we should talk about the form other than just make fun of how we use it. Paragraph 1 says, what the heck are we doing here? Like, so the recital paragraph says what property, who's in it, blah, blah, blah. Paragraph 1 says the agreement is a backup position number, whatever, and is contingent upon written cancellation. Come on, get me the cancellation, boy. Come on now, because you don't have anything until, according to this, you get written cancellation of any prior contracts or related escrows. You got to get the escrow and contract canceled to have it comply with this form, right? Between seller and other buyers. So if you're in backup number 3, you want evidence of cancellation for everybody, or you want to see if they had an escrow, or you want to see the cancellation of contract, because like I was just saying, you're in contract. Even if you're in backup position number 12, you're in contract. You can't get out of this deal without a cancellation. Now you have numerous cancellation rights as a buyer in this case. But if you're in backup position number 3, you want to see the cancellation of that first one and the cancellation of that escrow. And if number 2 said, we don't want it either, they have to cancel it. They can't just go, we don't want it either, unless you're the president of the Santa Maria Association, and you don't have to know anything, apparently. Sorry. She's long gone. I went to her installation, and I went there when they dethroned her. Yeah, it's better.
So you literally can have 2 transactions going.
Well, you don't have a transaction going on the second one necessarily, because you didn't open escrow or anything like that, but you can, paragraph 2, you could say, a buyer's deposit shall not be delivered to escrow holder until 3 business days after copies of the written cancellations, blah, blah, blah. Or you could open an escrow, but I don't know why you would process it, because it's, it's gonna get a little dicey, but you could. Or shall immediately be handled as provided in the agreement. So paragraph 2 says, yeah, I could actually open another escrow. You'll open it subject to cancellation of the escrow you're in. The contract even has this really nice backup offer addendum so that Kim and Steph aren't freaked out about, wait, I have this in another escrow with you guys and somebody else. What are you doing here? It's backup. We're just collecting a deposit and put some heat on this buyer. Paragraph 3 says, in the agreement, the time periods in the agreement for investigations, contingencies, blah, 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 shall begin after the backup guy goes in, or all time periods shall begin as provided in the agreement.
Like I said,
so you could run, yeah, I hadn't thought of it that way.
Close date, I'm
so,
closing.
However, if the date for close of escrow is a specific calendar date, that date shall not be extended unless agreed to in writing by buyer and seller. But you're also, the entire second transaction is subject to cancellation of the first one. So you're a paper tiger, but boy, that's a pretty powerful backup to have. The loan's approved, the appraisal's been done, contingencies are removed, yeah. And when that guy calls up and says, we think we want to renegotiate, now you just bought yourself a house somewhere else, bye. Tell the guy, hey, close it.
Yeah.
Like 3 days later or whatever, a week later, you're in. Yeah. Closing disclosure probably won't go out. I have no idea, because you're contingent on the other contract canceling. That would be a thing.
I mean, why would you pay to have the inspection?
Well, from the buyer's agent?
In this market, it's a hot property. You get 13 offers, take 2 of them, run them, and if the first person doesn't perform and you're a contractual tiger saying, you have this date and here's my 3-day notice and I'm gonna cancel you if you don't close, and it doesn't close, you get them out of the way in 2 days. Okay, you get them out of the way and all of a sudden you got 5 days to close this transaction.
Yep.
So this buyer's been running strong the whole entire time, hoping that this guy fouls out. So buyers, if it's a hot property, that comes around on.
That's why I say to write.
So you're talking being the listing agent.
Being the listing
Final
agent.
listing
Yeah.
agent.
Dream deal.
Huge
Now,
benefit to that. As a buyer's agent.
Because then you know that you're going to be.
Well, being the buyer's agent, right? I mean, you kind of want to tie it up like, we're going to have to do that anyway. Like, how do you guys feel about that?
Yeah.
There's no, I mean, the stronger we look,
beat out. Let's jump in a second position and hope that the first.
we'll run a transaction. It's going to cost you guys about $1,000. You up for that?
Yeah.
Does the listing agent have to disclose to the first party that there's a backup offer?
It depends what's going on. So if the, yeah, how about that? Why do attorneys have 2 hands? Well, on one hand.
Buyer 1 that's in escrow has a COP attached.
Oh, okay,
They
yep.
decide to take
Yeah, we
it
just did
back
the
in.
COP last week where I'm just.
That's a COP, let's just say it was a straight
Let's,
RPA.
okay, say it was an
Straight
RPA.
RPA, I don't think you have to tell them, now I gotta go back and
And
read
now
the
they've
damn
gone through and they've
contract.
sent requests for repairs and sellers going, no, I don't wanna do all this, let's just go ahead and let these people go and go to our backup offer, but do you have to tell that other agent, you have to disclose to the other agent that we have backup?
There has to be a spot in the RPA that talks about if you.
I don't know, yeah, I'll have to go dig that up. It's, I've always just used it as bargaining. I've never not told somebody that if I need it, you know, it's like I might tell them, you know, the only way you guys are gonna stay in this deal is be quiet, cause I got an accepted backup and they're chomping at the bit.
It seems like it'd be to your advantage to disclose.
Well,
Have a
sometimes you
backup
just
offer.
don't show your cards.
But that's a good card to have, that's your
That's
trump
your,
card.
that's your
That's your
leverage
card.
to make
Because if
that
you guys
work.
don't perform,
Right.
don't worry, I got
Straightforward
somebody
man.
right behind
You
you.
don't wanna tell them because that other offer that you're working on is higher and
Which one?
you're hoping that they leave the first one.
Well,
First
you
one's
force them
higher?
out. You
The
force them
second
out.
one's higher.
Second one's higher?
Yeah, you force them out, because you can't, if you didn't tell them or did tell them, at the end of the day, they have to contractually do something wrong in order to get them out.
You don't have to tell them what, well, of course, you're not gonna tell them what the price is on your backup.
No.
In the RPA,
But it's a leverage.
Gonna have,
in the RPA, there has to be a
Oh,
clause
I
that
see what
talks
you're saying,
about
you don't wanna
still.
give them a chance to play nice, you let them to get out.
Yeah. Yeah.
yeah, it's just up to the seller, you know, whether they, I mean, as far as what are you gonna do with that first transaction, like how tough am I gonna get? How much, and I think David's point's well taken, how much faith do I have in my backup guy? I got this great backup offer for $50,000 higher, but they haven't even put their deposit in yet. You know, like, yeah, I think it's an excellent point. It's like, yeah, how serious are you guys? I mean, you're 50 grand over on a $200,000 deal. Would you mind running your escrow?
If I was a listing agent taking a backup offer, I would make them start their timeframes immediately, not wait. And that would be my leverage. You
If
wanna
you-
get
if
in
you
on
get
this,
to do it.
because if not, I'll just put it back on the market and we'll just market it when you
Take your
cancel.
chances.
So you're gonna have to put some skin in the game if you wanna get into backup.
As if it had just treated as if it had fallen out of escrow and this is your lucky day, buddy. And it's just up to the buyer. They're either gonna suck it up or they're not.
But the whole objective is to accept offers.
If you're the listing agent,
Right.
Yeah,
And
I don't see why not.
if you get a better offer and they start their timeframes, it's no harm, no foul. You will definitely close this transaction around the date that you said you would, because if that guy doesn't perform, you're jumping ship and all you're doing is your CD and your loan docs and you're closing it. And you're holding their deposit, ultimately, you got 2 deposits on the
You
hook.
gotta look at like the
Your
whole,
seller loves you right now.
the whole picture on your first person. Is it an FHA loan? Are they using a program to come in for down payment? How strong are they? And that's when you make the decision, you know what, I'm gonna take backup offers in this because this is a great offer, but
Will you make the decision or you ask the seller, you give the seller's
You give the
feedback and
seller
advice?
feedback and
yeah,
you
the
advise
sellers
them.
make the decision.
you advise them, I know you like this offer, but let's go ahead and protect you. And I'm gonna make this suggestion.
And I'm glad you put the third line in, yeah, because you were just telling them what to do. And they'll ask, it's like, what should we do?
Sellers don't know.
What should
That's
we
why
do?
that's why
Let
we
me
have these
explain your
classes.
options. Yeah,
They
tell
can
them,
learn.
here's some things you can do, here's how they'll play out, which one do you like?
And
Because it's all your fault if you start telling people like, you know, you're crazy, get rid of that idiot.
I got corrected on my close of escrow demand to close. That is a 3-day, not my notice.
Oh,
to
I'm
perform.
sorry, you have to give a notice for reform for just about every, yeah, it's not that's not a demand to close opportunity
close.
necessarily.
Perform fee.
No,
2.
notice.
2 day.
Well, you can change it to 3. All these little time periods have little, you could change the,
Wasn't there an agent that would put like 20 days in there and hope that agents didn't catch it?
either I didn't catch it or. I'd say that's unreasonable. Don't do that to
Made
me.
her go
Yes.
deserve,
Yes.
is that it, the
Yes.
demand?
Yes.
That
That's
didn't
the
make
one
the
that said
cut
I
for some
had it
reason.
on
We'll
my
talk
desk.
about that in the contract.
That is, I've learned that is not good form, you don't.
It's amazing form. That's the only, it's not personal. It's the only
Yeah.
form you can make.
There's no
Yes.
other way to push the issue. If you've exhausted all your notice,
Well, it's like,
Stop playing nice and start doing what you said you're gonna do.
who you working for, like who hired you, who's paying the bills, you know, that kind of thing. Whatever side you're, like who do you have a
Don't get that
fiduciary
as an
duty to?
agent.
Who are you sworn
Don't
to
get mad
protect?
at the other agent because they're just doing their job. And just as much as you should be doing your job. Don't call the other agent names and this and that. They are working for their client. And this is, everybody agreed to this.
yeah,
Okay.
And that's the contractual mechanics, right? I mean, what are you gonna do?
I was,
Well, what are we gonna do, Melissa? We wanna like put some heat on these guys. Well,
yeah,
make
my
anybody
back was
mad.
against, my back was against the wall with this, the buyer. We go over the night before, we're supposed to close escrow, and the sellers have not even started boxing. So what do? What do you do? We're supposed to close tomorrow.
You just say no.
No worries,
No,
no
the
worries.
seller lives out of town, they couldn't make it.
Sometimes you drive the truck. Yeah. Sometimes it's 1 o'clock in the morning, you're in the third truck, and the phone buyer goes, get your crap, we'll come and get you
Maybe the
next.
listing agent get over there and start boxing.
The listing agent came up. She was screaming. So it was not a nice.
They got a button for that on your phone.
Hey, I used it. I did. I found that.
You know what
button
used to be
and
the
I
greatest thing
pressed
about the flip phone back in the day was you go,
it.
you hang up like a boss if you had a flip phone. You could smack it down, it would like clamp.
She said,
They're
my
gone now,
manager
hey.
told me to use a form. Your manager has your head up your butt.
Wow, so professional.
That's funny.
No, this is I'm not gonna disclose.
We're not gonna disclose it was
A
here.
very reputable agent
Is
too.
there?
Oh, Gary would say the name.
The initials are big.
So don't get mad when you get the form. Just know that they're wanting to close too. Shoot, now I'm getting forced.
Yeah, now I don't know what to do, so I gotta use this form, because all the niceness didn't work, and you kept like stalling me, like, what are you gonna do? And that's the trouble, you know, your contracts are made to be broken, you'll hear that all the time, and that's why they pay us the big bucks, that's why these are $20,000 deals and not 500, you know, I mean, that's the deal. Okay, we're a little bit over. We only got like 11 more forms to talk about, we've hit most of them. If you get into an exchange, that's all. Last thing I want to say, we have forms for that. Don't be shy. Call me, call David, call Angie, somebody.
You
might-
have
you might
numbers
need
on the
it.
number.
Oh, you'll have to email. It's always better anyway. Emailing your question makes them less easy to like muff, trying to figure out what you really want.
I'm sorry, Gary, quick question. Let's just say for instance.
You're forgetting.
I just go deep, right?
Did you remember what you wanted?
No, well, he addressed it actually, but, let's say it closes, the situation like that actually closes, and now that buyer has possession of that house and the contents.
Buyer doesn't have possession though, right? Are you telling me the seller's still home?
The seller is still
Seller
there.
still has
The
their
buyer didn't
stuff.
get possession. The buyer got title, didn't get possession unless they moved in on top of the seller, and oh boy, have we.
I think that's where I'm going.
I'm sorry, Mrs. Jones, you're going to have to get off that couch because I'm putting it in the truck. I got a letter to the DRE about that. The guy was saying, I got that woman out of that damn house. I was pretty new. Just saying, pulled up with the trailer and go, I'm sorry, Mrs. Sewell, stand up.
Yeah,
No
I have
movement. Yeah, that's a little rough, yeah.
Yeah.
And the agent that was nowhere to be found through the entire deals couldn't get to the DRE fast enough to talk about it. That's where I learned the letters of the DRE go nowhere. If
what
you're
can you do? So
okay.
what can you do? That's what your
I
arbitration clause is.
just went through that. It's it can be trying, and you gotta probably, I guess, a thing you do is like David said, like keep your cool. You can keep your head while all about you are losing theirs. That's a great chance to try that. Because the seller's like, I don't know who these damn people think they are, blah, blah, blah. And the buyer's going, what's the matter with that goofball seller? We just gave him $700,000. Get out of my house. Mellow that out. And you got to do everything you can think of to get that seller out. Now, this form, I don't know which form I have up now. Is this the right form? I don't think it is. No, back up. So the seller in possession form, which has now been changed to read seller's license to stay, the police are feeling a lot better about that because the attorneys are feeling better about throwing them out as basically not a holdover tenant, but as a trespasser. Like your license has expired. You don't have a lease. You're not a tenant. I just said you can stay there for a minute. Your minute's up. So if you get an attorney to tell a cop, like, I'll back you on that, they'll toss them. They'll unsnap that pistol and throw them out. I just went through that before we got the attorney to talk to the cops. Like, no, everybody was on vacation. It was August or July or something. Like, couldn't get a hold of Jay. I was going to have Jay do it because he was a cop. Anyway, we got her out. She moved. She stayed a little bit extra, but then we got her out. And somebody, not me, went down there like that minute with a bag full of locks and a screw gun, like locked her out.
And what about
Like,
all their
Drilled all
possessions
the
in there?
put screws in the windows and nailed them shut.
And
It's
what
like,
about the personal?
don't come back.
There's law regarding personal items that basically says you're gonna put it into a storage and then you gotta hold it for a certain point. It's
Just like if
personal
they're-
property addendum. And we.
Yeah, they treat that stuff kind of like a rental is. Yeah, it's just leftover crap.
I don't know why that agent
So it's a
just
post and
didn't
store
have a
outside.
conversation with you. She knew the sellers had packed up their stuff. She knew they needed more time. Why didn't they just ask for it instead of hiding out when
Well, that's
the
right.
day that they closed?
They were stalling.
They were stalling.
They were stalling.
Why?
We just,
Right?
we were done with the stalling.
We don't want to move Friday, we want to move next Friday. Well, why didn't you say something?
No, it
Jerk.
said, but it's raining. That was, remember?
Yeah.
But it was raining.
It was one excuse after another.
Yeah.
Yeah.
It's one excuse.
Gotta love it.
Always try to get that seller in possession, even if you get it for 2 days. Cause yeah, that's.
Get it for 2 hours. If it's the next day, right, it's after the close, it's gonna close October 5th, they're not leaving until October 6th, yeah. It's a one-page form, it's easy. They're staying until November, it did that with closed escrow in July, left lady in there until November, that was a hell of a piece to negotiate, I'm just saying. $2.5 million deal, seller says, you know, I'm not really ready to go anywhere, it's like, I don't know, the holidays, got that done. I don't
I've been
know.
trying to see.
So, Cornerstone
Why did I lose?
is doing pre-listing inspections. You call the inspector that you want to use. And they will
Gus
get you.
Vasquez told me that they weren't, so if Steve doesn't.
Oh, yeah, he just texted me. He said that they all do them. You just have to contact them directly, not through the website, and it's half the price of
Well, I talked to
this.
Gus in person when he did.
Okay, that's what
He
I'm
says,
wrong.
Steve will do
Okay, so I
it.
need to name.
So it's a possibility, right? I'm gonna try signing out without ruining everything.
Thank you, Gary.
All right, okay, that's it. We only have like closing first. So David said, hey, we better learn something today. Did anybody learn anything? Other than Yay! That one?
okay, you'll figure it out.
So Elizabeth, the good news on that, after you do your post and store on site, you get to keep.
Bye, Trish.
Yeah, if you want it.
If you want.
You want the crap
I should
that
say
they-
Hell's in me.
Uh,
Oh, stop sharing.
So those bank foreclosures,